office bearers, Mr. Shashank Dod and Mr. Vijay Sachiv, the learned faculty, Shri C.B. Thakurji, seniors in profession and my dear friends. Well, after the hectic VAT audit season which has just completed and the due dates of filing return of 21st, I think we all are now set for getting up for the assessments and the refunds and a tussle with the department. Well, to teach us on the subject and to dwell on the various issues pertaining to Form 501, we have a very learned faculty with us. But before inviting the learned faculty, I'll request Kunjapur to say a few words.
Respected learned speaker of 6th Circle C.B. Thakur, office bearer on the dais, my colleague in the managing committee, seniors in the profession and dear members. Very warm good afternoon to everybody. I am regularly receiving calls from our members regarding non-availability of refunds due to non-filing of Form 501. On this point, we are regularly representing to the Commissioner, but we are not getting positive response. We have seen such an Impex case where Honorable High Court directed assessing officer to some cases. Meanwhile, Vaibhav Steel Corporation decision came in respect of availability of 36-month time to file Form 501. Due to this type of peculiar problems, we decided to guide the members on this topic and kept this 6:30 circle meeting. And the speaker is Advocate C.B. Thakur. So let us hear from him the legal provision on this topic. Secondly, he will also touch upon the latest notification for exemption from payment of late fees by the particular class of dealer. Thank you. Thank you very much.
Coming to the pleasant task of introducing today's speaker. Well, friends, as such, no introduction is required of the speaker today, the faculty today, popularly known as CD. Full name is Chandrakant Bhai Shankar Thakur. He is a CA as well as an advocate, but now he is practicing as an advocate. He has been the president of the Sales Tax Practitioner Association of Maharashtra for the year 95-96 and also the past president of the Sales Tax Tribunal Bar Association for the year 6-8. He is a regular contributor of articles in magazines published by BCA, AIFTP, the column comes as Nuts and Crackers, the newsletters published by WIRC and the Sales Tax Review published by our association. He has also been the chief editor of the Sales Tax Review for the year 96-97 and 97-98. He has authored the book Study Materials for Beginners in Sales Tax Laws in Maharashtra for the WIRC of the Institute of Chartered Accountants of India. He is a member of the publishing committee of Guidebook on VAT Audit under Maharashtra Value Added Tax and Issues on VAT Audit published by the Institute of CA. He has also co-authored study material on Central Sales Tax for the Institute and is a co-opted member to the research committee of the Central Council of the Institute of Chartered Accountants. And he is also a co-opted member on the various research publication committees of the Institute and the other organizations. With these few words, I proudly present before you Advocate C.B. Thakur. I request Mr. C.B. Thakur to please deliver this talk.
President of our association, office bearers on the dais and all of you friends. Today I have to speak upon refunds and more specifically where the applications have remained to be filed. And we are all eager to see what will happen, etc., etc. The hall is also full. And I also requested President to bring some checks from the department that while discussing at the end of the lecture, something may be discussed. To the late filers. Anyhow, friends, the topic is really interesting as on today. And in spite of we are now in operation about 9th year, we are still getting calls that my 11, 12 applications remain to be filed or something like that. So, since there is no complete awareness or by any chance, whatever it may be, it is remaining to be filed, and that is why we are having these issues. Now friends, let us go through some background of the VAT enactment as it has come with big bang, that it will be very smooth operative and this and that. Now we have got all the experience for last 5-6 years because of the lack of infrastructure with the department, and on their part they were not ready to give the information about vendors, whether they have paid tax or not, etc., etc. And then now number of buying dealers are getting demands in very fabulous amount just because vendors are now not available or they have not paid taxes or whatever allegations are there. So the first hindrance which we are now finding in the VAT is about the tax liability itself. In spite of we have paid to our vendor, sometimes we are being made liable to pay again simply because my vendor has paid. Now that is one aspect of the thing. Another issue which will arise under VAT normally will be about the refunds. When we should get refund, because under the BST Act there are a number of declaration forms are available, like Form 14, BC form, EC form, etc., etc. So whenever vendor was not liable to pay tax or liable to pay tax lower rate, etc., he can issue that certificate. So his vendor will charge lower rate, and then normally there will be very few cases resulting into refund. But now under VAT there is no any such scheme for declarations, etc. You have to pay full tax, whether you are exporter or whether you are manufacturing tax-free goods, whatever it is. But you have to invariably pay while purchasing the goods to the vendor, and then when there is no liability or liability is on the lesser side, you will always be having the cases of refund. So that is why refund cases are many under the VAT Act. That is a regular feature. In refunds, number of issues are there, including refund against bank guarantee, etc. Now if you go to the Act says, that is means in the VAT Act, there is section 51 which provides for refund as per returns. And we are now normally operating in line of this section. And that is why we have to look into this section. What this section says: grant of refunds where a registered dealer has in any return, fresh return or revised return shown any amount to be refundable and has not undertaken to adjust such amount against the amount due as per any return in accordance with section 50. The commissioner shall, on an application made by the dealer and subject to rules and other provisions of this Act, grant refund of such amount to the said dealer. Now if you read this section, the obligation, the shall word is applicable to commissioner. So if there is refund in the return, then this section says that if the dealer has made application, commissioner shall refund him after following due procedure, refund. There is no any barring saying that once you go by section 51, there is no other mode by which you cannot get the refund. In other words, section 51 is not exclusive or doesn't provide that the refund should not be given except under section 51. There is no such any prohibitory language in section. So according to first interpretation reading of section 51, it is one of the modes we can say that if you have got a refund as per returns, one way is that dealer can apply for it under section 51 by filing 501, and commissioner shall grant him after due process of that application. That is the implication of this section. Because when we go further arguments, this will be also one of the contentions. What is the scope of section 51? Then friends, they have given what should be the modalities, how you should apply, etc. Before we go further, I only want to draw attention towards the provision for grant of refund against bank guarantee. Because my topic is something different, but before I go to that, I would like to draw attention, because against bank guarantee, department is supposed to give refund within 30 days. That is what law says, as well as circular 22T of 2010, which was issued by the London Commissioner, the then London Commissioner, that it will be given within 30 days. But now we have come across cases that against bank guarantee also they are not giving within 30 days, even if they are lying for a year together. And there is one judgment of Bombay High Court in case of Whirlpool India, where some observations are made by the Honorable High Court that in spite of bank guarantee, department can verify the application. So based on that, now they are taking time to verify your input credit and this and that in spite of your given bank guarantee. And that is why it is getting delayed and they are not very much, you can say, interested in giving the refunds promptly. That is our experience. So anyhow, according to me, whatever process they want to do against bank guarantee, they must do within 30 days time, because 30 days time is given for that purpose only. They may verify it, whatever they want, but they cannot delay your refund, otherwise it will be against the section itself, and one can argue or one can contest that issue based on that limit itself. So friends, I think this is what exactly against bank guarantee we can say. Now section 6, subsection 6 of section 51, which is one of the connected section, which says, if before the grant of refund under this section, a notice for assessment covering the period to which the return relates is issued, or any proceeding under subsection 3 or subsection 4 of section 64 are initiated in respect of the period to which the return relates, then if the dealer has not furnished a bank guarantee, then no refund under this section shall be granted, and if the dealer has furnished a bank guarantee, then an amount is paid for interest. Now section 6A again prohibits when, if before the grant of refund under this section, a notice for assessment covering the period to which the return relates. So even if suppose you have filed the application, but your assessment notice is issued, then till the assessment is completed, you cannot take benefit of section 51. That is the implication of section 51(6). Or suppose you have not filed the application and your assessment is taken up by issue of notice in 301, that is scrutiny assessment under section 23, 3, 4, etc. 2, 3, 4, not 23, 5. 23 by assessment is only transaction wise, as you are aware, and normally it will be taken up by the department where they feel that this transaction is giving lesser revenue or there is a loss of revenue, and that is only they will pick up. So there, I think other things are not open. So that probably will not be able to take it when the section 23(5) assessment is taken up. But department can certainly consider what is the position about that refund, that will come later on. Now coming to this section 6, subsection 6 of the section 51, if suppose you have not filed the application, let it be any year, but they issue notice in form 301 under section 23, 2, 3 or 4, then you can certainly put your claim, because then assessment has to be as per your records, and if that is showing your refund, then they are bound to grant you. So even if you have not filed application, still it will not have any adverse effect upon you. So one thing is that in respect of delayed applications, first thing you observe whether there is any assessment notice issued to you in form 301, then you are saved. Then no further things have to be done by you. If it is not there, then you have to go further. Now friends, I have scrutinized this position as per year wise. What will happen? Because application for refund, that is in form 501, and when the act came in 2005-06 first year, it was 3 years, and accordingly the time limits can be calculated. Now they have amended, that is subsection 7 of section 51, which is now amended in 2011, 1/5/2011 onwards, it stands amended. It now says, no refund under this section shall be granted unless an application as provided is made, and no application under this section shall be entertained unless it is made within 18 months from the end of the year containing the period to which the return relates. So from 1/5/2011, they have substituted the word 3 years to 18 months. So now after 1/5/2011, it will be 18 months. Now what are the situations arising? Friends, what happened in one of my cases which I have referred here, that is Vaibhav Steel Corporation. Now in this case, the year was 9/10 and the application could not be uploaded before 18 months from the end of the year, that is September 11. And then you are aware that time limit by circular was extended up to 7th January 2012 because of some problems in the system. So they themselves are extended up to 7th January 2012, but still it was not filed within that time also. And when they went for uploading after that date, it was not accepted on the website. Then a letter was written to the Commissioner of Sales Tax 8th floor. Now firstly we must remember there is no any particular authority for assessment this and that. So wherever you want, unless it is under assessment proceedings or some related division like registration etc., wherever other things are concerned, you should directly write to the Commissioner of Sales Tax 8th floor. Now we wrote letter to the Commissioner of Sales Tax that this has remained to be filed. However, kindly entertain it, or otherwise you initiate our assessment and see that we get our refund. Now that was rejected, saying that it is time barred, we cannot do anything about it. Against that letters, writ petition was filed. And of course when you go to writ petition, you have to take all the alternative arguments. We cannot stick to one only, that you must ask the department to carry on assessment. That is not the only argument. We took it in 4 or 5 arguments. The first argument was that my application is not time barred because refund is a substantive right, and in such of the cases where the right is substantive right, any amendment should be applicable prospectively. So our argument was that 9-10 period being prior to 1/5/2011, by which date section 51(7) was amended, that is why we are entitled to 3 years time. Only the period starting after 1/5/2011 may get covered by the newly amended section, that is 18 months etc. So we based upon both, saying that interpretation should be 3 years, and whatever circular commissioner issued saying that it is up to 18 months only for 9-10, that is to be struck down. So this is the first argument we took up. Of course after that there were other arguments also, that once the refund is shown in the return, it is the duty of the department to give us back. And even if you have not filed application, because what our argument was, 51 is one of the modes to go to approach the department for getting refund, but that is not the exhaustive. There is no prohibition that department cannot grant or the dealer cannot. So we can request to the commissioner that you either initiate my assessment and see that I get the refund. That was another alternative argument we have made. The third one which was made was, we pointed out attention to section 20 of the MVAT Act. That section 20 says, as you must have seen, section 23 is for the assessment and taking action by the department. 23 is about assessment by the commissioner, and 23(2) says, for example, where the return in respect of any period is filed by registered dealer by the prescribed date, and if the commissioner considers it necessary or expedient to ensure that return is correct and complete. So here probably, and that is what the even reply to the writ petition, department has said that it is prerogative of the department to take up the assessment if they want, but cannot be on the direction of the SSC. That is what they have intended in their reply. So this was my second argument in the writ petition, that the department should be directed to take up my assessment. And the third alternative which we prayed for was section 20, returns and self-assessment. Subsection 1A, every registered dealer shall file correct, complete and self-consistent return is in such form by such date for such period and to such authority as may be prescribed. Different types of returns may be prescribed for different classes of dealers. B, subsection B, the commissioner may examine the return to ascertain whether it is complete and self-consistent. If the return is not complete or self-consistent, the commissioner may serve on the dealer within 4 months of the date of filing of the return a defect notice in the prescribed form. The said registered dealer shall correct the defects and submit to the prescribed authority a fresh, complete and self-consistent return within 1 month of the service of the defect notice, etc. So we took an alternative third argument that if at all the department does not want to take assessment, then there is also no defect notice issued to me. So my returns are complete, correct, and there is a self-assessment because of section 20. So that because of that self-assessment also, I am now entitled to refund as per return. So either of the ways I must get the refund. Then in the writ petition you also pointed out section 50 subsection 1. What it says? Subject to the other provisions of this Act and the rules made thereunder, the Commissioner shall, by order, refund to a person the amount of tax, penalty, interest, security deposit, deposited under section 16, and fee, except when the fees paid by the law court, if any, paid by such person in excess of the amount due from him. The refund may be either by reduction of excess, etc., etc. So, section 50 subsection 1 gives direction that any excess payment should be refunded to the dealer. Now, if you say that my return is accepted and that is why there is a self-assessment, then whatever excess I have shown in the return is due to me as access to me. So we pointed out these two sections in the writ petition to the High Court that otherwise I am entitled to refund by way of section 20 reduced section 50 subsection 1. So friends, then our other grounds, constitutional validity, section 2, article 265, that government cannot retain amount more than due to it, etc., unjust enrichment. Then how I will be affected because there the refund claim was about 31 lakhs. And if we don't get it, how my business will get closed, etc. All these arguments we have put up. Now when the writ petition was filed and the reply was filed by the department, in the reply what I found is there is no much substance or any hardness in their reply. They only argued that when there is a system made in the Act, specific provision is made, the dealer cannot refer to general provision. That was one of their arguments. And another argument was that this is an attempt to take the refund backdoor. When you are not filed the application in time and still now you are asking by way of self-assessment, etc., that is a backdoor entry. That is what they have said in their written reply. And when the matter came for argument, I first pointed out to the Honorable Court that this is my first thing, my vested right. I cited two judgments and immediately they said this is what covered, vested right, refund is a vested right. So they that this, whatever amendment has come will operate perfectly. My plea is 910, they say that your application, which was of course filed in physical form before Commissioner, before March 2013, because the year was 910, so 3 years will be 2013, March 2013, and before that this letter was filed. So they said your application is time, then they have passed the order, this should be entertained as filing time. So now I am supposed to be get processed. Till today we have not heard anything, but I think this is going to happen. So friends, so the other arguments High Court said we keep open because there is no occasion to deal with all those arguments. So now another arguments are still open for argument. Now friends, here also the issue came about Sachin impacts. I have cited that judgment also. That if in the Sachin impacts, without filing refund application, when the Honorable High Court directed to make the assessment as early as possible to grant the refund, they have not objected. How can they now object to my request for assessment? This was also raised. Of course, High Court said that now we are deciding on this issue, that is why not we are going into that aspect. But our argument was that there will become a discriminatory. Somebody is getting where they have not objected, and now when I am coming with the same plea, you are saying that it is. Then department says that it was not argued properly, there was no such intention, this and that. So that is not the case. Once the High Court has said you have not filed a review petition, you have not said anything about that judgment, that means you accepted it. So if one dealer is going to get it based on the late filing of application without filing application, why other people should not get? So that point is still open. So now friends, what I want to conclude from this matter of High Court, that for the year 910, if you are not filing a refund application, but file a letter to the Commissioner saying that my application is remained to file, and it is filed before 2013, you are entitled to get it entertained. You can simply write a letter that this is the judgment, accordingly my application is in time, kindly I process it and grant the refund. If suppose for 9-10, you have not filed letter also prior to 2013, and now we want to file it, can we do it? Because now 2013 is over, somebody will say that you have not taken that chance of within 3 years also, then how now you can entertain? Right? So they should now make it open. That is what our argument. So based on that, if suppose 9-10 application still remain to be filed, you can still file it and say that because your misinterpretation and the system was blocked, my application was not getting uploaded after September, but now the Honorable High Court has correctly interpreted. So actually it should have been March 2013, but I was misled because of this, so now kindly entertain it. What will happen to this? Will it be accepted? No, definitely not. Then what to do? Again you have to go to them. Probably there are good chances it may be directed because there is a mutual understanding mistake or whatever it is. Mutual, or rather than mutual, it is a more mistake on the part of the department who has misinterpreted the law. And that is why, according to me, the time should get extended till they explain this position properly and give one more opportunity to the dealers to upload the application. That is possibility is there. But this has to be tested in the court. So this is what about 9-10. Now suppose you are filing letter for 9-10. Along with that also if you put your claims that if at all not maintainable, kindly assess me. Assessment time is I think still available up to 2014 March. So we immediately put the letter. And also make alternative that if at all not to be assessed, then you grant me as per self-assessment section 20, read with section 50 subsection 1. So all these points you should put in one letter and file the application in physical form and then wait for the result. If they are not replying to you, you can certainly file application under the RTI, what happened to my this letter. Some reply will definitely get. Based on that, then further approach has to be done to the High Court. Then friends, 10-11. Now this amendment has come, as I told you, effective from 1/5/2011. And the law says that it should apply, amendment in section 51(7) should apply from 1/5/2011. According to me, 10-11 is prior to that. So for that also we are getting 3 years. So for 10-11, the time limit will be up to March 2014. So anybody's application has remained for 10-11 till they can file up to March